Hi. So I was starting my stream today, and then at the very beginning of the stream, someone's like, "There's a motion to dismiss." I'm like, "Motion to dismiss? What are you talking about for the Sarah Boone case?" Someone in the chat just wrote, "Did you see the motion to dismiss and the docket uploaded late yesterday? What the heck? Question mark? Question mark? Refer to judge. Motion to dismiss case/charges with constitutional authorities. Once in jeopardy on 4/13/2020 arraignment." I don't understand what any of this is. Authority. The Constitution of the U.S. Amendment 6, specifically the right to a speedy trial, has been violated. The state of Florida has not met the requirements or proven good cause of delays. Ineffective. Who spelled that? Substandard state provided attorneys should have made this request long ago, proving this is a fact. I'm assuming she waived her right to a speedy trial because she was still working with her private attorney at that time. But is she trying to go back in retrospect and say, well, I didn't know that I could have waived my right? Maybe she'll say that she didn't waive her right to a speedy trial and that her attorney did it without her permission. Oh, gosh. So you can tell at this point, I am confused because I thought maybe Sarah Boone filed it, even though the format looks very different. But it wasn't until later on where I realized, oh, this was not filed by Sarah Boone. All she attached here is the Bill of Rights. We have Amendment 1, 2, 3. Wait a second. Does she have representation now? Huh. All right. Well, very interesting. If you guys haven't seen my last video, we covered Winston Hobson. Winston Hobson has not been paid yet, it seems, and he is requesting JAC to pay him a flat fee of $15,000. However, JAC is like, well, you weren't Sarah Boone's attorney from beginning to end, and because of that, you don't get the full $15,000 flat fee. You know, it doesn't matter how many hours you worked on it, I guess. But then, in order for him to attempt to even get paid what he's requesting, he needs to request a hearing from a judge. And in addition, he needs to include other attorneys that worked on Sarah Boone's case, other court-appointed attorneys. So there's Winston Hobson, which is attorney number 7, Mr. Frank Bankowitz, attorney number 6. There was a Mark Consalo, which was attorney number, I don't remember which one, but barely worked in Sarah Boone's case, I don't believe. And then there's Patricia Cashman. So JAC is saying that, like, well, that $15,000 flat fee, y'all need to figure out and divide it between the 4 of you guys. And everyone's like, no. We want our $15,000. We worked a lot on this case. And that's what we're going to get into today. So we're going to look at Frank Bankowitz. He filed a motion. We're going to look at Patricia Cashman, also filed a motion as well. And with Patricia Cashman, we get to see a breakdown of what she worked on in Sarah Boone's case and what direction we can see, you know, what they're pivoting to, at least when she was working on it. Because we're like, well, what is Sarah Boone's defense going to be? And we all thought that, you know, maybe she's going to go over the battered spouse defense, because I think that was mentioned with Frank Bankowitz. And it seems like maybe Winston Hobson and Patricia Cashman, they're just going to continue with that defense. Anyways. So, but before we get to all the attorney drama stuff, I also wanted to look over these notes with you guys. Now, you guys remember the judge, he wants to have like a log of Sarah Boone, you know, getting her stuff. So like he wants a log of like when Sarah Boone gets her laptop, when she gets her discovery, the thumb drives, discovery boxes and stuff like that. And I guess every week someone goes in there and they upload the interactions that anyone has with Sarah Boone. But with the interactions, we're getting more details. It's not just, oh, Sarah Boone's getting USB drive, Sarah Boone's getting a thumb drive, Sarah Boone's getting a laptop. It's like, oh, we're also getting some behavior notes on here, which, you know, some of us are very nosy and it's kind of interesting to read. So I want to go over this with you guys. This came out a couple days ago and I was going to wait because I didn't want to just cover this on its own. I was going to wait till other stuff came out. So now that we have a bunch of things, this is actually pretty interesting. So we get to see the interactions with different officers, people who are trying to visit Sarah Boone, the dates and times and all that stuff. And we got all this here. And I'm pretty sure, you know, this wasn't really like the intention, but because all this is being uploaded for the judge to see, we on the internet, we get to see it as well. All right. Let me go back to, oh gosh, let's go over here. Boone might have a lawyer. I don't know. It seems like someone filed something on behalf of her. So maybe possibly. So let's get into some of the Sarah Boone notes. Let me put my glasses on actually, because all right, so we got some logs here with Sarah Boone. Let's see, on 8/6, Sarah Boone got her thumb drive, discovery hard drive, and I think the laptop as well that was assigned to her. Same thing happened on the day, or no. Oh, this is when she turns in her laptop. So the laptop, thumb drive, discovery hard drive returned. On 8/7, the next day, she got her laptop, USB, discovery hard drives in her dorm. 8/7, inmate verbally refused breakfast. Same day, Boone returned the laptop, USB, and drive at 1600 hours. Inmate Sarah Boone was called out for an attorney visit. Ooh, in FDCB dorm, inmates stated, "No, I don't have an attorney. I've had too many random people coming in to see my case. I took the paperwork from my attorney and delivered the paperwork to inmate Boone." So I wonder if it's just someone who might be interested in representing her, which this is what we want, right? We want her to have proper representation. I prefer to have someone to represent her rather than having her do it herself. All right, 8-8. The next day, inmate Boone was advised at approximately 21:59 hours that she had an attorney visit. Inmate Boone requested to know who the attorney was. Being that she has no attorney assigned to her, inmate Boone said that she did not feel comfortable visiting anyone that she does not know because crazy people have been reaching out and scheduling visits with her, claiming to be someone they are not. Oh, I remember hearing about this in one of her letters where she said that someone came to visit her and she claimed that the person wasn't very transparent, that they were a journalist or something like that. Or I forgot who it was that came to visit her. And she was like really pissed that they're trying to come in and like get the tea or something. I don't know. I just remember seeing in one of the letters that she wrote. Inmate Boone was notified that the attorney's name was James Wax. Ooh, I don't know how to pronounce that. Waxewski. However, due to inmate Boone's attorney's delay in a response on whether or not she wanted to meet with him, he dropped off her case files and departed. When inmate Boone was given her files and notice of the attorney's departure, she began to remember who he was and became upset. Inmate Boone mentioned that she has met with him previously and that he traveled from Tallahassee just to meet with her. It was explained to inmate Boone that we are not responsible for his departure. She was notified of his presence, and her delay in response resulted in his departure. Sergeant Moreno was made aware of this information. Same day, she got her laptop. All right, so it seems like she's like working on her laptop. I spoke with inmate Boone about the items in her property. Inmate Boone said that she has everything she needs to properly represent herself. This entry is for informational purposes only. Also, I wonder, I noticed that a lot of I's pop up. I don't know if there's a weird autocorrect in their inmate behavior note system or something, but you'll see a lot of like weird spelling errors, but very consistent same spelling errors later on. Inmate Boone returned the laptop, thumb drive, and hard drive to this officer at 14:25 hours. Items was returned to the control room. Inmate Boone turned to a request form attached in the letter of Captain Dio Giovanni. Corporal Don Pat received the letter and gave to Sergeant Jesus due to Captain Dio Giovanni's name not being here. Wow, lots of names that are pretty hard to. A little bit hard for me to pronounce. It will be given to her upon her return. Inmate Boone was made aware, informational purposes. And again, this is her receiving USB, laptop, boxes of discovery. And we have a inmate Boone exit for an interview. I'm not really quite sure what that means. Inmate Boone returned all her USB, cord, and laptop later on in the day. She refused to have breakfast. Inmate Boone received the laptop, USB drive, hard drive, USB cord in the beginning of the day. And then at the end of the day, she returned all that. So we had some inmate notes here. Again, this is something the judge requested just so he can know that, okay, well, every day, she's getting her stuff that she needs, and then she's turning it in. All right, so later on in the day, or later on in the week, inmate Boone returned the laptop with 3 USB, 1 hard drive, USB cord. Inmate Boone returned to the unit from the attorney interview. Inmate Boone returned to unit from attorney interview with laptop, hard drive, USB drive. So I wonder if there are people that are interested in representing her. Again, we're on the next day where she was given some stuff, but she refused due to her going to court. Oh, that's right. She did have a court appearance that day. Inmate Boone was advised not to wear her altered inmate's blue uniform to downtown court. While inmate Boone appeared for her scheduled court appearance, it was discovered by CRSO Jones that Boone had altered her county-issued blues with staples alone, the seam of her pants legs. Inmate Boone was counseled for this negative behavior, informed that her blues were considered contraband, and issued more blues. I wonder why she decided to maybe she just wanted to look more tailored and look better, I guess, in a court appearance, maybe. Inmate Boone was given 2 property bags to secure her discovery documents. Inmate Boone was also given several manila envelopes. Inmate Boone's laptop was available and provided her at 2000 hours, informational purposes. Later on that day, Inmate Boone notified staff that she was not sure that she was going to use the laptop because she was unable to get internet. Inmate Boone stated that she will let the staff know when she's ready to use the laptop. So again, she requested to use the laptop. She requested to have access to the internet. I was actually kind of surprised that the judge didn't allow it. I guess like when you're going pro se, it really does suck. Like you don't have access to internet. It's really hard for you to have longer calls with people. Like I don't know. It really sucks. It just seems like fuck. Like I don't know. I don't know why I thought that they were going to give her more freedom, but it seems like this is just how things are done, which makes sense. When you're like an inmate, you're not going to have the freedom to do things that you want to do. Laptop was provided to inmate Boone. Inmate Boone requested a small uniform shirt verbally from inmate requesting form. Inmate Boone complains about the small uniform shirts issued to her was an improper fit. It was too big. So this is her just trying to get clothes stuff. Da 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 da. But what I'm really interested in is just like the people that it seems like, maybe she will get some representation. It seems like there are people that are trying to meet up with her. At least that's what I'm getting from some of these inmate notes here. Inmate Boone requested a smaller inmate uniform. This is just uniform stuff. We don't care about that. So this is her getting her laptop. Blah, 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 blah. So I actually have not looked through this file yet. I looked through the other one. Inmate Boone was in an interview with a professional visitor. The visitor informed staff that he had legal mail for inmate Boone. Sergeant Dunn, Corporal Hall, and I searched inmate Boone property. During the search, the following items were amongst her legal mail: paperclips, staples, clear Ziploc bag. Man, I'm actually surprised at how detailed everything is, and it's all logged in here. But I guess that does make sense. As a dorm officer, I am aware that inmate Boone is to receive a laptop per set schedule. Oh, okay. So this is the issue that she complained about with the judge. Or was it with the judge, or was it an emotion that she wrote? She complained how she would receive the laptop and the battery would be dead. I'm also aware that she tends to use it frequently. However, I noticed today she didn't ask for it since my arrival to shift. I then asked if she would like to utilize her laptop privileges, which she said, yes, I have been wanting to use it, but you didn't ask me. I was told you guys are to ask me if I want to use it. I'm not to ask any questions. It should be noted that inmate Boone has been briefed by staff regarding her laptop usage since she first received it, and is to ask the dorm officer for it if she would like to use it. Again, she did notify me that she would like to use it any time. Since my arrival to shift, she received the laptop, and Corporal CP Ward, I think Corporal Ward maybe there's an L in there, was notified. Moments later, while I was conducting a visual inspection, she stated to me the laptop was low on battery, to which I looked and confirmed that it was. So I'm assuming they can't give her a laptop charger because maybe it's a cord and then maybe can use it to like harm herself or others. I'm assuming that's why she doesn't have it. Which, I don't know if you guys, I don't know. I feel like when you're working on a laptop, I feel like batteries tend to drain pretty quickly. Inmate Boone then requested a statement form stating this is my third day in a row that's been given to me with a dead battery. Yeah, that's a huge issue. It's supposed to be charged. May I have the statement form that they give you guys to document when I don't have the laptop? I want to write about my laptop constantly being dead, which is fair enough. She was given the form, the laptop was placed on a charger. Inmate Boone is currently pro se, is allowed a laptop for scheduled hours of the day. Inmate Boone Sarah is currently pro se and is allowed a laptop for scheduled hours. Laptop had low battery and needed to be charged. Is this the next day? Same thing happened? Laptop had low battery and needed to be charged. An entry was made hours ago by this officer regarding the battery and Inmate Boone requesting the statement form. While collecting the form from Inmate Boone, I informed her the laptop is now charged. Oh, it's now charged. Okay. And should be ready for use in the morning. I also told her that I will make the day shift officer aware that the laptop is to be charged when she is finished using it, so she can utilize it during the night shift. Inmate Boone then stated, Ms. Ford, I would take the form back. I didn't really want to turn it. It's okay. I will keep it in the documents. Just please let the officer know that it has to be charged. I can't do anything without it. Okay, so I hope they get all that squared away with the laptop not being charged. But like I said, like I don't know if she's really doing much work. No, it's a lot of her discovery stuff is on the laptop. So I was like, can she just forget the laptop and just do all the hard copies that she has instead? But there's videos and files that she needs to view. So, well, that makes sense to me. All right. So I wanted to go over the attorney stuff. I don't think the hearing for the attorneys are going to be streamed because it doesn't really involve Sarah Boone. It's not like Sarah Boone's hearing. It's just the attorneys doing their thing in the background. But I'm sure we'll get to learn the end result of it to see, who's going to get paid and if they're going to get paid the $15,000 flat fee each, or if it's something where they have to take it and divide it amongst all of them, which would be kind of like, especially seeing how much time has been spent to work on her case. And then there are people in the chat who was wondering, why was there a new judge assigned to Sarah Boone's case? Lisa T. Munyon, also in Florida, Orange County Courthouse. I don't know. I'm confused what's going on here. I guess let's wait for Law and Crime or Court TV to get us some info. I'm not quite sure what's going on here. So we still have the trial scheduled with Judge Kranig. That's a judge that we all like. And we were all confused for a second, but we got our answer. Okay, what is this? You were hereby notified the undersigned on the 24th of... Oh, yeah, you guys are right. So if we just kept looking at the court docs, we would have our answer. You are hereby notified that the undersigned will be on the 24th day of September 2024, the hour of 9 o'clock a.m. God, what a convoluted way to write that. I hate this. Sorry, Patricia. We love you. Call upon before Honorable Lisa Munyon. chief judge of the above style court at Orange County Courthouse. Oh, wait, there's a WebEx here. Oh, maybe we can join them. You think it's open for the public? Okay, so we have our answer. Remember how people were like, oh, why is there a new judge over here? Okay, that's for the attorney's fees. We got our answer. Mr. Hobson, attorney number 7, was trying to get his flat fee of $15,000. And I'm sure the other attorneys are also joining in because they are trying to do the same thing as well. I want to go over Patricia Cashman's motion for her attorney fees because she goes over what she worked on for the Sarah Boone case, how many hours she spent with Sarah Boone. And, we kind of get a glimpse of the direction that Sarah Boone's defense is going. But who knows? Now that she's her own attorney, she might just take a 180 and do something different. We'll see. So Patricia Cashman, just an overview. Mr. Frank Bankowitz was attorney. Actually, you know what? I should read Mr. Bankowitz's motion first because he was attorney number 6. So Mr. Bankowitz, poor guy, he was with Sarah Boone for, I think, over like a year and a half. Now, I say poor guy because a few months in, he was trying to withdraw. The judge didn't allow him. That was the judge at this time, Mr. Wayne Wooden, did not allow Frank Bankowitz to withdraw. And Frank Bankowitz had to work with Sarah Boone for about another 9 months before he finally tried to withdraw again. And that was granted. And of course, when you're looking at the letters, I'm sure the judge looked at it and was like, oh, okay, so you have your client calling you a buffoon, an idiot. It seems like things are very hostile between the two of you guys. So maybe it is a good idea to have you withdraw and we'll get someone else to work on Sarah Boone's case. So this is Mr. Frank Bankowitz. Let's read his motion before we get to Patricia Cashman. Mr. Bankowitz. Motion for attorney fees. So Mr. Bankowitz was a court-appointed attorney for this case. Number 1, the undersigned attorney was a court-appointed to represent the above defendant, Sarah Boone, on or about July 11, 2022, wherein the defendant has been charged with second-degree murder. Undersigned counsel was attorney number 7 to this case. That the undersigned... Was he number 7? I thought it was number 6. 6, 7, 8. I think he was number 6. Yeah, he's number 6. I think that's wrong. The undersigned attorney worked on this case for over a year, has spent approximately 175 hours, including 45 hours with the defendant. That on or about June 28, 2024, this court entered its order finding that the defendant had forfeited her right to counsel after having 8 different attorneys appointed to her case. Then each attorney ultimately withdrew from the case. Part of this order read that the defendant was not entitled to endless lines of court-appointed attorneys until she found one that she preferred. Number 5, counsel was seeking a contract fee of $15,000. So like I said, everyone wants their $15,000 flat fee. They don't want to divide that $15,000 amongst 4 attorneys. They're like, we worked on this. We want $15,000. So that's Mr. Frank Bankowitz. All right, Joel. So this is Patricia Cashman. And with Patricia Cashman, much respect to her because if you're going to be asked for compensation for the work that you did, I really liked how she outlined everything. I don't know if Frank Bankowitz may have maybe he has his own exhibit that he hasn't attached yet, but this is really good because you can't just be asking for money and not show the work for it, right? It's good that she has all this documented. Good for Patricia Cashman. But who knows? Maybe Winston Hobson has the same and then Frank Bankowitz has the same as well. Or Patricia Cashman is just really, really freaking organized. Okay, so Patricia Cashman, she was appointed as attorney number 8. So again, we have Frank Bankowitz, attorney number 6, and then things didn't work out. We had Mr. Hobson. I think Mr. Hobson represented Sarah Boone for about 5 months, maybe. If anyone knows, correct me. I think it was about 5 months. So Mr. Hobson, he was the one who, it seems like, to initiate all of this. He's the one who's like, okay, well, I'm ready to get paid. Let's do this. Come on. So things didn't work out with Mr. Hobson. And then next we had Patricia Cashman right here, who again was with Sarah Boone for, how many months was Patricia Cashman with Sarah Boone? Maybe like 5 or 6 months, maybe? She'll say it in here. The undersigned Patricia Cashman was appointed counsel for the defendant on February 9, 2012. She was the 8th appointed attorney and the 4th private court appointed attorney. The undersigned is now billing on this cause because the case has reached a billable point. JAC's response to the billing was to object to the flat fee of $15,000 for attorney's fees and the $1,800 for reimbursable costs expended by this attorney, and a hearing is requested. I looked at the JAC letter. It seems like they objected to the $15,000 flat fee, but they were okay with reimbursing her the $1,800. A copy of this objection letter is attached. So here's the objection letter. Let's zoom. Oh gosh, can you guys read this font? Ms. Cashman, JAC has received and reviewed the motion for attorney's fees as the above referenced matter. JAC will not be filing a formal response and takes no position as to your motion, except JAC objects insofar as the estimated attorney's fees exceed the statutory presumption of non-indigence. It has to like roll off your tongue for it to sound natural. Otherwise, it sounds really weird. Non-indigence. JAC does not request to participate in any hearing set on this motion. You may utilize this email in lieu of a formal response and should attach it to your motion while you provide it to the court. The undersigned is now billing this cause because the case has reached a billable point. Okay, so she wants a $15K plus the reimbursable. Now, this is where she's going to go over how much time she spent on the Sarah Boone case. The undersigned counsel represented defendant for over 4-month period. Counsel spent over 100 hours on said case as evidenced by the attached certificate of time marked in Exhibit 2. Over 20 of those hours were spent with the defendant. 4. Boone was charged with second-degree murder. There's a vast amount of media attention to this case. Ms. Boone was accused of putting her boyfriend in a suitcase where he died. There's a video of the incident that went viral. Counsel made preparing this case a priority as the case has been pending since February of 2020. The final disposition of this case was the court entering the order that Ms. Boone had waived her right to counsel. There's a significant amount of discovery to review. Multiple CDs, DVDs, paper discovery of over 400 pages of report statements, 2 banker boxes of files obtained from previous counsels, and background information on the relationship between the deceased and the defendant. The state listed 23 witnesses, 2 of whom were deposed by this counsel, and 7 who were deposed by previous counsel. There were 8 separate statements given by the defendant. Counsel also needed to review the media accounts that potential jurors may have seen. The case was heavily covered by Court TV, News Nation, Fox, local news channel, the Orlando Sentinel. Know your lawyer. No, know your. Wait, is this wrong? It's supposed to be Okay, so my brain absolutely broke here. I don't know why it just broke. It really did break. It's not know your lawyer. This is supposed to be Peter Tracos, right? Legal Bites and Bruce Rivers did multiple stories on their channels. Now that this name tripped me up, now I don't know what the real YouTube name is. What is the real YouTube name that I'm thinking of? Lori, okay, Lori, you know. I was like, wait, what's the real YouTube channel? Know your lawyer. That's funny. No, you're a lawyer. Lori, you know. Okay, I think they she probably just got it. She probably wrote it wrong. Oh, maybe this is the real YouTube channel. I don't know. Many of the previously held court proceedings were televised, and the letters written to the defendant were published and analyzed. The defendant wrote a 58-page letter to the court and had previously written multiple long letters to the court that counsel needed to review, to determine the potential impact of the case and develop a strategy for the jury selection. That's a lot of YouTube videos to watch. Counsel has spent over 20 hours at jail conference with the client. Undersigned counsel has submitted a voucher to JAC for the payment. Hey, MLG, how are you doing today? As a result of the undersigned counsel's acceptance and work on the above style case, counsel was unavailable to meet with several potential new clients who then hired other counsel. Opportunities to take on new clients had to be declined, resulting in a loss of fees. Because of what is outlined above and work done by the attorney, failing to pay the fee as requested would be confiscatory. Yeah, that like tripped me up, like seeing that. I was like, no, you're a lawyer. That's not right. Okay, so JAC has no objection to the reimbursement of the expert witness fees in the amount of $1,800. However, JAC they reject the $15,000 billing fee for the following reason. So they're basically saying because there's so many different attorneys appointed to this case, that flat fee will just have to be divided by the other attorneys, unless the court decides otherwise. You were appointed to this case, but you did not represent the client through the entire course of the case. Thus, the court appointed more than one private attorney to represent this client. The court must apportion the flat fee among all the private court-appointed counsel who worked on this case. In this matter, you were the 4th of the 4 attorneys appointed to represent the defendant. Because the court must apportion the flat fee among all private court-appointed counsel, the matter must be heard before the court in a single hearing. So, I hope they're going to get paid. Okay, so now we get to see what Patricia Cashman, the work that she did for Sarah Boone. Divided? No way. That just seems so unfair. Now, if it was because the attorneys are assholes and they chose to withdraw, sure, I don't know. but it seems like, it seems to be Sarah Boone, not the attorneys. Okay, so on February 9th, we had a status hearing, conference with client, conference with ASA, email correspondence with previous attorneys, email correspondence with previous investigator, email with ASA, discovery, draft and signed letter to jail, email correspondence with jail. Same day. Begin to review the progress docket on the clerk website, review client info on jail website, review suitcase video from the internet, 15 minutes, draft and sign the letter to state for discovery. On the next day, continue to review progress docket on clerk website, begin reviewing discovery. Next day, continue reviewing discovery. Next day, continue reviewing discovery, email correspondence with previous attorney, correspondence with previous investigator, phone conference with previous attorney, review Brady notice from the state, review witness list. February 13, continue reviewing discovery, review state response to demand, email correspondence with ASA, review email from unknown person about the case. On the 14th, email correspondence with ASA about discovery, email correspondence with previous attorneys, text correspondence with previous attorney. The 16th, jail conference with client, 4.7 hours. Review supplemental discovery notice, review court order, hearing status. On the 19th, review deposition notices to determine which witnesses have been deposed. Email correspondence with previous investigator, review previous investigator's report, 18 pages. On the 20th, conference with previous counsel. The 21st, draft letter to client, prepare enclosures, review score sheet, review supplemental discovery notice. The 22nd, phone conference with the expert, email conference with expert. 23rd, review material received from previous investigator. On the 24th, she reviewed the deposition of Moses Torres, which is one of George's brother. B. Boone, I think is Sarah Boone's ex-husband. J. Martinez, not quite sure. Marisol Torres, Marisol. I don't know if George had a sister, maybe mother? K. Rodriguez, there's a B. Torres, and S. Robinson. On the 25th, review media on the internet. Jurors will have been exposed. So Legal Bites, WESH, I think is it a news station maybe? Yes, the lawyers were all mean to Sarah. It can't be Sarah's fault. Court TV, Parkland judge weighing in, 12 minutes. Review digital file from the investigator. On the 26th, she reviewed boxes from previous counsel. 27th, email correspondence with the jail, conference with the client. March 5th, draft letter to expert, prepare attachment. March 6th, prepare for a client conference by reviewing previous correspondence of client, review case law to respond to client questions. On the 7th, jail conference with the client for 2.5 hours. On March 11th, draft and sign letter to client, prepare enclosures. The 14th, draft and sign letter for the expert, email correspondence with the jail. On the 15th, email correspondence with the jail, edit letter per jail request. On the 16th, review the depositions of De Leon, Johnson, Carwise, Zeidowicz, and Roughgarden. Maybe experts? Not too sure. For 2.6 hours. On the 17th, review the deposition of Motes, Battaglia, Juan Torres. On the 18th, review file to determine additional depots to be set. Draft, sign letter to client, prepare enclosures. On the 20th, review jail conference with the client for 2 hours. Review and sign letters to law enforcement officers. On the 23rd, compare and contrast statements and depositions for about 5 hours. March 24th, draft and sign letter to client after reviewing correspondence from the client, prepare enclosures. On the 29th, phone conference with the client for about 0.3 hours. Legal research on issue client had questions about. For 1, email correspondence with the jail. For 4, review correspondence and documents from client to prepare for jail visits. Jail conference with client. Phone conference with previous counsel. Email correspondence with previous investigator. On the 5th, listen to the 911 call. 9 minutes long. Was it 9 minutes long? I don't remember it being 9 minutes long. B. Boone is a Brian Boone, the smart man, the GTFO of the relationship. 4-5, listen to the 911 call in 9 minutes. Watch the suitcase video. Oh gosh, I can't believe she probably had to watch it like over and over again. It's so hard to watch. On the 5th, watch 8 BWCs. Review correspondence with the client. On the 8th, jail conference with the client for about 2 hours. Review documents from the client, 20 pages. Email correspondence with ASA for the status hearing. Draft and sign letter with enclosures to the client. For 10, review materials from the client. For 11, phone conference with the client for about 0.3 hours. Prepare packet from discovery to provide to client, attorney-client privilege. 412, jail conference with client, 4.3 hours. A status hearing, conference with ASA, review correspondence from the client, 74 pages. Oh gosh, 2.5 hours, 74 pages. On 415, draft and sign letter to jail expert. Review court order on the status hearing, reset. 422, jail conference with client, leaving a voice message for a potential witness. Email correspondence with previous investigator. 423, legal research on battered woman syndrome. Legal research on PTSD. So again, Sarah Boone has requested to hire a neuropsychologist. She said that she experienced trauma at, I don't know, maybe like at a young age or something that has affected the way that she reacted in the situation somehow during the night, I guess, when George was in the suitcase. I don't know how she's going to use a defense. I feel like any jury that listens to that is just going to call bullshit on it, but who knows? Maybe her expert will go up there and maybe convince us otherwise. 423, legal research on battered woman syndrome, legal research on PTSD. 423, correspondence with the expert. 426, jail conference with the client for half an hour. Listen to voicemail from media. 429, phone conference with the client for 0.2 hours. Draft and sign a letter to jail for a visit. Email correspondence with the jail for a visit. Draft and sign letter with the for an expert. 430, email correspondence with jail for a visit. I mean, it looks like she's working on this case. Like I don't know how many other cases Patricia Cashman had at this time, but I mean, it seems like she's working this case, and things are getting done. But, it seems like whatever Patricia Cashman is telling Ms. Boone, she's not happy with, because Patricia Cashman has said that Sarah Boone has walked out of their meetings before. So I don't know. I guess like once we get to trial and then we see Sarah Boone representing herself and putting on the defense that she wants, then we'll see, oh, okay, this is probably why the previous attorneys didn't want to go this route, because maybe it just looks really ridiculous. But jail conference with the client, half an hour, listen to media, blah, blah, blah. Sorry, I was over here. 430, email correspondence with the jail for a visit. 5-1, correspondence with the expert, draft letter to jail, email correspondence with the jail for an expert. 5-3, jail conference with the client, 1.1 hours. Review correspondence from a client, 12 pages. I wonder if these are just, I wonder if this is like her letters to Patricia Cashman, like complaining about like, why aren't you doing anything? You're lying to me. Review police reports, search warrants, clients' statements, prepare for depots, draft questions. 5-7, take the depositions of detectives Kopsel and Lowen, conference with ASA about the case. 5-9, phone conference with a client's family member. I mean, she has her ex-husband. I don't know if she has like other family members. Email correspondence with potential witness, review Brady notice from the statement, review supplemental discovery. 3-11, draft and sign letter to client, prepare enclosures. 5-14, so about 2 months later, listen to voicemail from the media. 5-15, draft and sign letter to the client. 5-24, review correspondence from client, 10 pages. 5-26, review client's 3 statements. 5-30, phone conference with the expert. Review correspondence from the client, 6 pages. Review client's additional 3 statements. 5-31, draft letter to client, prepare enclosures. 6-1, review witness list to determine if additional depots needed to be set. 6-2, review items from the client to prepare for jail conference. 6-4, jail conference with client, 0.2 hours. 6-5, draft letter to client, listen to 2 voicemails from the media. I wonder what the media wants. 6-6, listen to 3 voice message from the media, review email from the media. All right, we're almost there, y'all. 6-7, conference with the client for 0.3 hours. Conference with ASA, trial status hearing, listen to voicemail from media. 6-10, listen to voicemail on from media, review media on internet. Jurors who have been exposed to court TV, 26 minutes. I think there's supposed to be something else here, but I don't know. Know your lawyer, 1 hour, 40 minutes. 6-11, research conflict of interest per Florida bar rules, draft, edit, and sign motion to withdraw. Review court order from status hearing. 6-13, phone conference with ASA. 6-21, status meeting on the case. Review 58-page letter client wrote to the judge. I'm pretty sure we read that one. Additional research on the motion to withdraw. This one, she's like, get me out of here. Get me out of here. 6-27, review letter a client wrote to the judge, 4 pages, and a conference call. 6-27, draft orders for court request. 628, hearing on motion to withdraw, review court order, 16 pages, correspondence with the state, clarification of the order. 7-1, draft clarification order for the court, correspondence with ASA. 724, review clarification order entered by the court. And 725, review court order discovery stuff. So a total of 118 hours that Patricia Cashman has worked on this case. And I think she does a good job at detailing it all. I think this is the money that she wants to be reimbursed. So, Patricia Cashman, what do we got here? Court reporter appearance fees, 125. Deposition costs, transcripts of deposition costs, and then mental health. The following invoice has been submitted and attorney's waiting reimbursement, $1,800. Kind of funny. It's kind of like, oh, the mental health toll that this took on me, this case, I want $1,800 reimbursement. But I know that's not what she means. She probably meant that like they probably had a mental health expert or something, and then she just wants to be reimbursed for the $1,800 fee. That's the attorney stuff. We'll wait to see, what happens with that. Like I said, I don't think there's going to be an open hearing about that because, it's kind of one of those like none of our business thing, and it's not like a Sarah Boone related. Well, it's Sarah Boone related because, they all represented her, but I don't think it's a hearing where they're going to have it open to the public. I don't know. I mean, to me, it'd be interesting.